It's great to be back with all of you. We are that much deeper into January of 23, and we're keeping our promise to you. We spent the last two of our broadcasts looking back at what we learned from 22. And now that we are beginning to peer ahead and get our roots in this new year, we wanted to give you a chance to, with us, try to figure out what may be coming in a variety of different domains. So this week, as well as next week, our programs will be devoted to our predictions for 2023. And you'll all have to hold us to it to see whether we get it right. But in all seriousness, we're looking forward to giving you our sense as to where things in the realms of legal and policy developments are going and how they'll affect all of you. So with that, let me get to the agenda, please, Kathy, on the next slide, and I'll walk everyone through today's program. So I'll start with a look at the health and public health matters that, of course, have been keeping all of us so focused over these last years, really. And then Pete Jones, who is back with us, a previous host of this program and very regular contributor, will be talking about the NLRB and what's going on at the board. Thereafter, we'll have a chance to hear from Lou Orbach and Greg Riley, who will be presenting together on class actions. After that, Maureen Milmo will be with us from the Syracuse office looking at employee benefits. And then I will conclude with an effort to make sure we address all of your questions. And with that, let's begin. So thank you all again for taking the time to be with us for this special program. Last time I was with you hosting 2 weeks ago, I presented about the woods that we're seeing still that we're trying to figure our way through, and those woods are ones that I'm hopeful we'll find our way out of over the course of 23, but there are still a variety of issues that we'll be paying attention to in the health and public health domains. For instance, masking. We know for the most part, we have seen that masking requirements have gone away. What we expect is that in the healthcare delivery domains, those are unlikely to ultimately be rescinded in any meaningful fashion. But in the rest of our lives, broadly, we can expect we won't be seeing too much in the way of masking requirements as we progress into this year, barring any major change that we'll be here to tell you about. Staffing is a huge issue. We know that across the healthcare delivery domain, not just in New York State, not just in New York City, where I'm speaking with you from, but really across the country, there has been just an unprecedented demand on what it is to deliver healthcare delivery. And there are just too few people in many instances to do it. And that has led to great volatility in the marketplace. And so there are certainly going to be efforts focused on getting that into some better sense of rationality and control over the course of 23. Governor Hochul's interested in it. We'll get to that in a moment, but that's one to watch too. With COVID sick leave, we know that those who tune in here regularly often ask, when is that sick leave going to be ultimately taken off the books? For now, it remains there, and it will take legislative activity to change that. We are not yet sure whether the legislature is going to take that on, but we'll be watching that. With quarantine and isolation, there we expect to see that continuing relaxation that we were seeing at the end of 22 and over the course of the preceding months last year. We'll be watching, though, if there are changes, and that would be, again, I think, dependent on if there is an escalation in the public health risks. For now, thankfully, we're in a position of better management. And so we don't really expect to see a lot of change, New York State beefing up its policies, for instance, in this space. And with vaccination, this is an interesting one. We know that there are lots of different dimensions to this, both in terms of the workplace and just generally in terms of availability, further how it affects our population immunity. All of these kinds of factors are ones we're watching. The FDA just this week has come out with essentially a signaling that it's looking to make the COVID vaccines like the ones we get for flu, where will be an annual rite, an annual ritual, as it were. And for those of us who have, particularly difficult issues to manage that might make someone more vulnerable, there might be a recommendation to have more frequent vaccination in those instances. But this is all still developing. We'll all be watching to see whether, just as we get our flu shots once a year, we'll be doing the same for COVID. More to come there. Next slide, please. And then getting back to the public health burdens, there we know that there is absolutely that triple-demic still in place. We're learning our way through it. It will be interesting to see whether it abates over the course of 23. The good news is that the seasonal flu that everyone worried about being just so dominant in the midst of figuring out RSV and COVID, the worst that had been feared didn't really happen. People got together over the holidays and there wasn't a tremendous spike. And we're actually seeing the incidence of seasonal flu dropping in important ways. So we'll be tracking this closely. We also do know that this super contagious version of Omicron is circulating, and people continue to get sick, unfortunately. But the good news is that if people are vaccinated and or otherwise exposed previously to COVID, it's a nuisance, but nothing more. Obviously, there's some individuals for whom it is still, a very trying experience, and the healthcare systems around our state in New York as well, the country, are still focused on those individuals too. And so we'll keep an eye on that as we move into the year. The public health emergencies, all of you know that at the federal level, those have been extended numerous times, most recently earlier this month. The tea leaves tell us as well, plenty who are watching, that those are likely to be the last conversations around extension that we'll see. In April, when this current extension expires, it's almost a certainty that the Biden administration is going to allow the public health emergency to lapse. And with that, we'll see a whole number of changes with regard to regulatory flexibilities we've been living with, deriving from the federal level, that will go away. What stays and what is otherwise changed forever, that'll be part of what's developing over 23. Telehealth is one place where, certainly in realms like behavioral health, what we've seen in terms of how telehealth extends the reach, that's likely to stay, and that'll be something I would bet is permanent. What we will likely, though, see is less use of telehealth in some of the more traditional hands-on types of care delivery environments, and we already are seeing trends in that regard, but we'll be watching that. Next slide, please. Just moving through quickly, we want to make sure that you're aware in New York State, there's a significant amount of attention focused on whether ultimately we're going to see in the vein of $13.5 billion flowing through New York as the next stage of healthcare redesign. That's another big open item. Back in the 2010s, moving into March of 2020, New York State across the healthcare environment was working through a 5-year run of billions of dollars under the Delivery System Reform Incentive Payment Program, which essentially focused funds on healthcare redesign in New York State. That all wound down from a funding standpoint anyway in March of 2020. And there's an effort underway with the New York State Department of Health in conversation with CMS at the federal level to, in a re-envisioned way, really with a focus on what's been learned through the pandemic, looking at health equity, bringing in new money to the tune, of billions of dollars into New York State. The likely outcome will be that we will have some amount of that money coming into the state beginning this year. We don't know exactly when. It was thought that we might have it already based on some of the signaling we were seeing late last year, but we'll be watching, that very closely, because the implications for healthcare delivery broadly are really profound. Next slide, please. And it's also budget season. We know that Governor Hochul, as I signaled before, is focused on staffing. She's delivered her State of the State address. There's a complicated political environment where, of course, the Judiciary Committee did not see it fit to see Judge LaSalle through. And so there is this fight, as it were, as between the legislative and executive branches that is part of the context as the governor negotiates the budget, which will be signed into law on or about April 1st, as is required. There'll be one House bills that we'll see in the interim, and there's a lot of healthcare material that's been posited by the governor, including a commission on the future of healthcare, agency staffing reform. So more to watch there, and we'll be keeping you all up to date. Next slide, please. And finally, just a quick note before I turn it over to Pete. We're watching privacy issues that intersect with healthcare. And what we have at the federal level is a pretty broad regulatory sweep. For those of you who weren't in the weeds of this, there's something called the Cyber Incident Reporting for Critical Infrastructure Act of 2022. That's resulted in CISA, which is a federal agency in charge of cybersecurity, in the process of developing what we really sweeping regulations when they're ultimately implemented that will touch on privacy, including in healthcare. It'll be interesting to see the ways that HIPAA, which is really how privacy is managed at the federal regulatory level, folds into this or not. These are going to be really significant open questions that we'll be tracking over the course of this coming year. More to come for sure, but we just wanted to highlight this as something to watch. And why don't we move then please to the next slide, Kathy? And with that, I'll introduce Pete. And Pete, we're thrilled to have you back as always. Pete, of course, hosted this broadcast for many moons and did so during the worst of the pandemic. And so, Pete, we're both grateful for your regular and sturdy voice before this audience, as well for your willingness to come on back from Syracuse to help us understand as a group what we can expect from the NLRB as we peer ahead into 23. Pete, the floor is yours, and thank you very much for your time.
Thanks, Gabe. And it's good to be here. Good to be back today. I want to look back a little bit as we look forward, because I think that's kind of what Gabe, you were suggesting we would do. Kathy, if you could move forward to the next slide, please. So really, we did an update in December. We periodically update you on what's going on at the NLRB, and there's been an absolute flurry of activity within the past year. There have been general counsel memos, some of them, very well publicized, such as the potential impact on college athletes. Some of them less so, but more broadly applicable, such as the general counsel's position on remedial action or captive audience speeches. There have been just a number of different position papers put out by the prosecutorial arm of the NLRB, the general counsel. There have also been new board decisions, invitations for briefing, which often predict new board decisions, because the board says, gee, we think this is an important issue and we're thinking about potentially changing the decisional law. We're going to invite briefs from interested parties so that we can make sure we get it right. There's been rulemaking and the potential for more rulemaking in the offing. And so we really wanted to break down the implications for both union and non-union employers, because the National Labor Relations Act does in fact pertain to both. Okay, so next slide, please, Kathy. So we had previously reported on this decision, American Steel Construction. I'll just briefly summarize it for those of you who might not have been on or who may not remember. But there's been this ongoing debate at the National Labor Relations Board about the standard for an appropriate bargaining unit. And an appropriate bargaining unit is a very important concept because it identifies who can organize. And so the size of the group and the composition of the group that would be in the voting group and ultimately in the bargaining unit if a unit is certified becomes a pretty important question. And the board has flip-flopped on this over the years. The 2011 decision, and especially healthcare, created the concept of so-called micro units, that is, small units comprised of a group of employees that might exclude others who had historically been included. And the American Steel Construction case took us back to the specialty healthcare standard, but it basically places the burden on the employer to demonstrate an overwhelming community of interest among the excluded employees and the petition for employees in order to change the bargaining unit. Okay, so what does this mean? And Kath, if you could jump forward to the next slide here. What it means is that the petitioner, in this case, the union, has the advantage of picking the proposed unit. And so they can pick the size and the scope, and one that they obviously think they're going to have strong chances of prevailing and being selected as the bargaining representative. And the employer, the respondent, has the burden of demonstrating that some people have been inappropriately excluded, that it should be a different unit, a bigger unit, comprised of more employees who share the same community of interest. And because that standard, the burden is on the employer and the standard is high, it's not a difficult prediction to say that unions are going to get more units that they prefer as the petitioner. And those units are likely to be smaller and designated in sizes and groups that improve the union's chances of winning that election, because the union can pick their groups. Okay, so we end up with the potential for more elections, smaller groups, and potentially more bargaining. That opens up a couple things. First of all, it could be administratively difficult for an employer to have, a couple of small bargaining units potentially, as opposed to one big bargaining unit, because there are economies of scale in each bargaining unit, or maybe the concept is inefficiencies of scale. Each bargaining unit requires a certain amount of attention. And so the more you have, the more work you have to do in negotiating a contract, administering a contract, attending grievance meetings, et cetera, et cetera. The other thing that crops up if you've got, multiple potential bargaining units in the same workplace is the potential for whipsawing. That is, one group bargains for something or, threatens to strike in support of something. And then they either get it or they achieve their goals. And then the next group tries to build on what's been achieved and also achieve more, and so on and so forth. When you're talking about a large bargaining unit, you deal with all the issues at one time. So the backward looking piece here is that the board has changed the standard as we have reported to you. The forward looking piece is that we think it's likely to make organizing more easy and challenging bargaining units more difficult. That might result in more organizing, and it will result most likely in more difficulties for employers in responding to union organizing activity. Okay, next slide, please, Kathy. So that's on the organizing front. The other development that we've talked a little bit about, and I want to sort of, emphasize again today, is the board's decision with respect to damages that are available in unfair labor practice proceedings. And it's always been the case that if an employer or a union is found to be in violation of the National Labor Relations Act, that the board has the authority to fashion make-whole relief. But the board has recently, following the general counsel's lead, created a new standard: the direct and foreseeable pecuniary harm suffered as a result of the unfair labor practice, which is opening the door to potentially additional damages depending on the type of case you have. So things that the board has talked about are things like individual employee out-of-pocket healthcare costs if they lost their health insurance in conjunction with an alleged unfair labor practice that's found to have merit. The cost of cleaning their clothes, or getting a new toolbox, or potentially losing a car or a home due to the loss of income. These are things that are much further down the line in the chain of causation from traditional remedies. And so the Thrive decision has the potential for broad consequences. Let me spin that out for you a little bit. In the next slide, we'll talk a little bit about what it might look like if we get into individual cases. And Kathy, if you could go to the next slide, please. Disparate treatment cases arise under the act, basically it's a discrimination charge. Somebody saying I've been treated differently due to my protected concerted activity. And it's applicable in both a unionized and a non-unionized environment because the act applies in both places. So the traditional remedies, this make whole remedy that I've been talking about, cease and desist from violating the act, potentially post a notice so that employees are aware of their rights under the act, back pay, reinstatement. These are the kinds of things that have happened in individual discrimination cases or group discrimination cases. This new standard that I mentioned, the direct and foreseeable damages, is much broader and more unpredictable. And the employee's circumstances will matter. And foreseeability is kind of a very difficult concept to predict. Is it foreseeable that when an employee was terminated, for example, if it's subsequently found that it's due to their protected concerted activity, that they would have lost their car because they lost their income and couldn't make their car payments, things of that nature. So it's potentially a very impactful decision in the sense that it's going to be much harder to predict what kinds of damages might be available in these so-called disparate treatment cases. And one of the things I would like to mention is that, for unionized employers, you also have a grievance procedure, and there's a concept of deferral to arbitration that is applicable in those contexts. But this still applies. The National Labor Relations Act and the anti-discrimination provisions found in Section 8A3. And so you might find more interest in trying to be in front of the National Labor Relations Board as opposed in grievance arbitration if the remedies that are available are potentially broader. Okay, moving on to the next slide. Now let's talk about the duty to bargain, the impact of this case on those sorts of things. So unionized employers have a duty to bargain with the union under Section 8A5 of the Act regarding the so-called terms and conditions of employment. And so the traditional remedy when you don't bargain about something is, again, cease and desist, post a notice in order that you bargain in good faith. But we have heard, from the board that they may be interested in pursuing things such as bargaining schedules and progress reports and increased insulation periods where the union couldn't be decertified as additional remedies for violation of the duty to bargain. There are other remedies that have been referred to in the general counsel memo, such as reinstatement of proposals that have been withdrawn, a reimbursement of bargaining expenses, training of supervisors and managers. These are remedies that have never been sought and might be subject to the criticism that they're speculative or punitive, that they go beyond what has traditionally been thought of as make whole relief. So I would say that the scope of this is unclear, where this ends, what the board might order, and what the courts might countenance if these cases are appealed. But the short headline here is that, for an employer that has a duty to bargain, either because they've got a newly certified union or they've got an existing bargaining relationship, the board is going to be much more broad in its concept of what might be recoverable. So those are really the two updates that I wanted to share with you today. That's the forward-looking piece based upon the recent history. And we're going to keep you updated periodically on this with some additional updates on what to look for at the NLRB. And Gabe, I think we've also probably teed up in the employment area some EEO updates as well, some predictions on the next year. So
absolutely, Pete. And it's just such a help to have you back on the program. Thank you for taking the time. And I want to give our next speakers a chance to also walk us through some of their predictions. What we're going to be doing is now switching to class actions. We have two of our members of the firm, Lou Orbach from Syracuse and Greg Riley from the New York City area, who are going to be together discussing what we expect to see during 23 on class actions. Each of them is, very experienced in class actions from differing perspectives, and it'll be really great to hear from that collective wisdom that they'll be bringing. So Lou and Greg, the floor is yours. Thank you very much for taking the time. And let's hear what you have to predict for 23. Thank you.
Thank you, Gabe. Next slide, please. Anyway, what I'm going to be mostly talking about our employment law developments. Lou's going to add some stuff about other developments, but employment law developments that create the risk of class actions. Next slide. So whenever a new statute is passed or a new case comes out, I kind of look at it from a perspective of, well, this is interesting, but will it cause possible class action work, which is what Lou and I do. So what kind of statute or case law creates the risk of class actions? Any law that requires compliance for a group. For employment law, it'd be a group of employees or a group of employers, but it could be a group of businesses, a group of consumers, a group of companies that are bankrupt or going bankrupt. So you're looking for groups, a law that applies broadly. Next slide. So this morning or this afternoon, I guess, I'm gonna review a few, and there's quite a few, but I'm just highlighting some examples of laws that were passed last year, toward the end of the year, and some laws that are on the horizon. And those are the lists that I'm going to be looking at. Next slide. The first one is this New York State Pay Transparency Law. It has its origins in the idea that certain groups, particularly females, may be underpaid because they are not receiving or they may not ask for the type of pay that they're entitled to for a job, and that people who have more experience and or negotiate better may not get or they may get higher pay. And it's an attempt to create pay equity or make it more fair. And when people get a new job, it's trying to make it more fair about what pay they get. I don't know if that'll work, but that's the idea. So how do they do that? They make it so that the employers starting last year on September 17th, they have to provide employees or applicants with a range of pay that will be available for the position that they're either applying for or they're seeking a promotion for or a transfer opportunity. This new law applies to New York State employers with 4 or more employees. So it's a very broad law. Most employers are going to be covered, except there is a carve out for temporary help firms. And the employers are supposed to keep and maintain records and connections with this law. So you have to include the history of compensation ranges for each job, promotion or transfer opportunities, and the descriptions for these positions. You have to keep records. It resembles in some ways the kind of records you'd have to keep as an employer for wage and hours things. You have to keep records for all the employers. And significantly, it doesn't preempt local pay transparency laws. And there are a few local ones, and I list them here: New York City, Ithaca, and Albany and Westchester County. So they're not preempted by this New York State law. So employers in New York have to be aware there's a New York State law, but there also may be local laws that apply depending on where your workforce is working or where you're located. Right now, it's not, the way the statute's written, it's to be enforced by the New York State Department of Labor. but and it's not clear if there's a private right of action, whether a class action could be brought in court. But I'll tell you that there's other New York state laws where it doesn't say there's a private right of action. And you find out later through litigation that the courts say, yeah, there should be a private right of action. And I'm thinking in particular more recently of the manual worker class actions that our firm has been handling. There's nothing in the manual worker portion of the employment law that says that that's class action where there's a private right of action. But nonetheless, the courts have approved them. So next slide. As if it's not enough, and is usually the case, New York City also passed its own pay transparency law. It's very similar to the New York State law. It has some differences, though. It also applies if there's 4 or more employees. The differences are it does include staffing companies, temp companies. It clearly provides for a private right of action, but only current employees can be sued. You get 1 free pass if you're the employer, if you don't provide the salary or wage ranges for a new job or a promotion opportunity or a transfer. And the New York City Department of Consumer Affairs, they changed the acronym, but that's what I always call it. New York City Department of Consumer Affairs enforces this with fines up to $250,000. The takeaway, though, I want to just convey, kind of consistent with what I said earlier, is that it applies across a group of employees. So if you don't implement this law and you don't keep the records, you're risking a class action. And that's, if there's a takeaway from the presentation, that's the one I'd like to give. Watch out for these laws that apply broadly to a group of employees. It's not like a workers' compensation case or an unemployment case or a case where you're dealing with the alleged discriminatory termination of an employee who get, that's can be isolated to one employee. This kind of law applies broadly to groups of employees. Next slide. So new one. This is a kind of a high-tech kind of thing that's been going on and being used by many employers. It's automated employment decision tools. And a lot of employers are now, or have been, using tools that make it or reduce or create a screen to getting a job or getting a promotion. And these tools will do things like run artificial intelligence based on information provided by the applicant that will look at things and do the screening process. Do you have a high school education? Where do you live? What's your level of experience? What groups are you in? They may do a social media search, and they do this review, and then they screen out the candidates or employees that they either don't want to hire or don't want to give a promotion to, and they use it as a tool. And the tools themselves could be useful, and to reduce the applicant pool or the pool of people that might get a promotion. So you can see why employers want to use them, but the concern is that the tools themselves may create a risk of discrimination, a risk of disparate impact, if you will. And that risk is, I mean, it was recognized by the Supreme Court a long time ago in the Griggs versus Duke Power case. Basically, the power company had a rule that you had to have a high school education to be hired at the power company. Well, it turns out most of the jobs didn't even require a high school education, and that had a disparate impact on African-American applicants. So that was found to be illegal. This kind of automated employment decision hiring tool or tools may have that same effect, and that's what this law seeks to avoid. Private right of action is available. So if you have a bad tool, you can not only bring a claim on your behalf of yourself, but it would be on behalf of all other applicants or employees that were subjected to the tool. They're working on compliance regulations or rules or guidance. They haven't come out with them yet. This is the DCWP, which used to be called the Department of Consumer Affairs in New York City. This law is effective April 15th of this year. It was supposed to be January 1st, but they pushed it back because they don't have the guidance out there yet. So just another law. It hit our radar screen because, again, it applies to a group. Next slide. This one's kind of self-evident, but virtually every year there's changes in the minimum wage and tip credits are affected. Here, there's been an increase in the minimum wage. So upstate New York counties, with some exclusions, you can't continue to pay your employees the same amount for minimum wage, which it also affects service employees and food service workers who are seeing an increase in the amount the employer can use as a tip credit. Tip credit, if in case some people may not know, it's basically for some employees in certain industries, like service employees and food service workers, the employer can credit their tips against the minimum wage. So they don't have to pay minimum wage as long as the employee receives enough in tips to cover the balance of the minimum wage that's not being paid by the employer. Next slide. Okay, this one's interesting. In New York City, I'm in New York City. We're on the bleeding edge of employment law. I don't know. I know we're competing with California and New Jersey, but we're really on the bleeding edge. And this one is particularly a bleeding edge. In New York City, there's a proposed law. It's been passed by the city council, but it hasn't been signed by Mayor Adams. There's a proposed law to get rid of basically at-will employment, which has been kind of the common law for not just decades, but literally centuries. It goes back to English common law, which always is held, and I've told clients this many times, you can terminate an employee for a good reason, a bad reason, or no reason at all, as long as it's not an illegal reason like discrimination or the person's a whistleblower. But you can usually, in the scheme of things, for decades, if not centuries, terminate somebody for any reason, as long as it's not an illegal reason. This law, if it's signed off on by Mayor Adams, would cover employers of any size, and it would put the onus on employers to prove that there was just cause, that there was a good reason for, actually more than a good reason, a just reason for terminating an employee. Alternatively, if it was a case of a downsizing or a mass layoff, the employer must show a bona fide economic reason for the layoff or the termination of the employees or the employee and employee. That is a sea change in how law usually works. I'm not aware of any other jurisdiction that has sought to make such a vast change in the at-will, basically at-will doctrine that's existed. This particular proposed law, obviously, like the other ones, applies to a group. So the employer has to make sure all employee terminations are for just cause. They have to give 14-day notice of the employee's termination, and that why it's a good reason. And they have to ideally use progressive discipline in doing it. So that's a real difference. We'll see if it passes, but again, it applies to a group, and it would be administratively burdensome. And those records you'd have to keep could be used in future litigation, and certainly would aid any plaintiff's counsel in making a class action. Lou, did you have anything else you wanted to add? You're on mute, Lou.
I think that's a great presentation of the employment law issues, Greg. The only thing I would add, and I know we're running law and we want to get to Maureen and her presentation on employee benefits. So I would say 3 things to look for outside of the employment area in class actions this year. Certainly, we've seen a record number of consumer class actions, consumer deception, consumer protection type claims, whether they be billing practices or packaging, consumer products. Certainly in a time of inflation and tightening budgets, we would expect to see a continued increase in those. Otherwise, I think that the class action world is going to be consumed with data collection, data breaches, data privacy. We are seeing a nonstop increase in those types of class actions under a variety of different federal, state, and common law type theories. And then the last thing I would say for business people to look for is continuing litigation, legislation, and regulation regarding class action waivers. Those are typically enforced through the Federal Arbitration Act, through arbitration agreements. Just last year, President Biden signed an amendment to the Federal Arbitration Act, which effectively will curtail the use of those in terms of cases of sexual assault, sexual harassment. There are bills pending in Congress regarding a broadening of those prohibitions to antitrust cases and other types of consumer cases and other cases as well. And we'll be keeping an eye on that.
Thank you so much, Lou and Greg. Hugely informative conversation, and we'd love to have you back to see whether these predictions are ones that come to fruition. Thank you for taking the time to pose them. And let's shift to our final speaker for the afternoon, Maureen, who's with us from Syracuse, who before joining Bond was a law clerk at the NLRB and assisted administrative law judges with litigation relating to the National Labor Relations Act, and is here to talk about employee benefits and what's on the horizon. So Maureen, the floor is yours. Thank you so much for coming back on the program.
Thanks, Gabe. I'll be highlighting a few employee benefit considerations for the 2023 plan year today. I'll be focusing specifically on 3 topics that I see as the most impactful and of interest to employers. Next slide, please. The topics I'll be discussing today are the recently passed Secure Act, the ongoing and increasing retirement plan litigation, and the national emergency considerations. So Congress recently passed and the president signed Secure 2.0 as part of the appropriations bill at the end of last year. So this bill has significant retirement plan impacts in it, and most of these changes are for 2024 and 2025. However, these first 2 changes that I'm discussing will impact plan sponsors now. So if you take nothing away, these first 2 changes are for the 2023 plan year. Next slide, please. So the first Secure 2.0 provision really impacts your older employees. So this takes effect right now, 2023, and this change is to required minimum distributions. So under the old 401k rules, employees had to begin withdrawing 401k amounts and were being taxed on those amounts at age of 70 and a half years old. So Secure 1.0, a previous bill, increased that age to 72, and now Secure 2.0 has increased this age to 73. So this change starts at January 1st of this year, and this increased the age again to 73. So by 2033, the RMD age will increase to 75. Next slide, please. So starting with the 2023 plan year, Secure 2.0 also permits employers to offer de minimis financial incentives not paid with plan assets. So we've seen this as such as low dollar gift cards to increase participation. So we're just starting to get questions now about the taxation consequences of such incentives and what structuring an incentive might look like. So we're keeping in mind this is a brand new law, and it'll definitely take some time to get some guidance from the IRS, from the Department of Labor. So continue to stay in touch with Benefits Council if you're looking to implement such an incentive. Next slide, please. So the next few changes will definitely take place in 2024 and 2025, and we know a lot of plan sponsors work several years in advance, so these are just a few considerations when planning for future plan years. So first, Secure 2.0 will require employers to require employees to enroll in 401k plans. So this is an automatic enrollment provision. This automatic enrollment will be with a minimum of 3% and a maximum of 10%. Employers can opt out, they do have that option, and current 401k and 403b plans are grandfathered in, so they do not need to comply with this requirement. So this automatic enrollment will not take place until the 2025 plan year. Next slide, please. So Secure 2.0 will also enable plan sponsors to make matching contributions to employees' 401k accounts for amounts employers are using to pay off their student loans. So looking to address student debt, lawmakers provided employers the incentive to put tax-free contributions into employees' 401k plans. So to stay competitive, this is a benefit that employers can start to provide in the 2024 plan year. Next slide, please. So this also impacts your older employees. So employees over 60 years old can double their catch-up contributions into their 401k. So if an employee is over 60, they can contribute $10,000 or 50% more than the catch-up amount to their 401k plan. So this will go into effect for taxable years after 2024. Next slide, please. Another provision has to do with emergency withdrawals. So under former rules, if an employee takes out money from their retirement savings, they get penalized pretty significantly. And Secure 2.0 now allows employees to take out $1,000 a year for emergencies without a penalty. This provision also enables plan sponsors to provide a retirement plan linked emergency savings account, and this is for non-highly compensated employees with a maximum balance of $2,500. So this provision starts in the 2024 plan year. So as you plan for 2023 and 2024, look out for a few of these changes, and they're definitely going to require some changes to your retirement practices. Next slide, please. So now a different topic. We have seen increased and ongoing litigation in the retirement plan space regarding fiduciary duties. So this is very similar to the Hughes v. Northwestern case, which we have previously talked to you about, which has caused quite a stir in the plan sponsor community. And this is caused by participants in retirement plans suing plan sponsors, investment committees, and plan administrators. Next slide, please. So these participants allege that employer defendants have breached ERISA fiduciary duties by failing to monitor investment record-keeping fees, offering class funds with higher fees instead of lower fees, and offering participants an excessive number of investment options, causing confusion and poor investment decisions. So the trend we've seen is the courts have sided with participants when employer defendants fail to address fiduciary duties. So prudently review your retirement portfolio and related expenses, and based off the litigation which we foresee continuing, you can't just pass off these duties to a record keeper or a third party and think you're safe from some of these lawsuits. Next slide, please. Finally, the COVID-19 national emergency and its impact on health and welfare plan sponsors. So Gabe touched on this briefly. The national emergency was declared due to COVID-19, and it includes a couple impacted plan requirements and participant deadlines. Next slide, please. So the national health emergency is still ongoing, and as Gabe noted, it's set to expire in April of 2023, not February of 2023. This shows how much of a moving target this emergency period has been. So unless the national emergency is extended by the president at the later date, impacted time periods include COBRA election periods, COBRA premium payment dates, notification for a qualifying event or disability, period for filing benefit claims and appeals, and the period for requesting special enrollment. Next slide, please. Next slide, please. So these are just a few issues that will require some pretty significant changes. So that's all from me, but feel free to reach out with any questions. Gabe, I think you're on mute.
Yep, you're muted, Gabe.
I apologize. Thank you. I was muted and now I hope that everyone hears me. I wanted to simply say thank you, Maureen. It is really appreciated information that you shared. I know we're a bit over time, folks. We are really glad that you have stuck with the program today. Next Tuesday, we'll have part 2 of our peering ahead into 23. Look for that program and tune in. And then as we flip into February, we'll return to our more standard schedule. But we are just grateful for your continuing commitment, and we look forward to being back with you in a week's time. Have a terrific afternoon. Thank you.